Waiting for the court to get back in session in Michigan for the Jennifer Crumbley case. They are on the verge of closing arguments there. The court is back in session, and the judge, Julie Nicholson, on the stand going over some preliminary jury instructions, which leads me to believe that they are skipping any sort of rebuttal by the prosecution. Don't write me down on that one. But that's what it looks like. So let's go back into court right now while she goes through some of these instructions, and we'll see where this thing is going.
5.10 needs to be amended.
Oh, okay.
Detective Wigorowski was an expert, but I don't believe there were any other experts admitted, were there?
No, the two medical examiners did not testify.
Sean Bryant, Katherine and Bryant.
Yes, Judge.
We stipulated to their autopsy reports.
So it's just Wigorowski, correct?
Yes, Judge.
All right. 5.11, 16.10. There's several of those. As to count 1, 16.10 as to count 2. That's involuntary manslaughter instruction. 16.10 as to count 3. 16.10 as to count 4. There's a unanimity instruction that is based on and adapted from 20.30. non-standard civil jury instructions, and the parties agree to that instruction.
Yes, sir.
Correct?
Yes.
Yes.
Okay. 16.13, involuntary manslaughter, failure to perform legal duty. As to count 1, 16.13 as to count 2, 16.13 as to count 3, 16.13 as to count 4, 16.15 as to count 16.15.
Just one instruction for 16.15.
Say it again?
Just one instruction for 16.15.
I was trying to see. I think there were some things again. Foreseeability excerpt.
Yes,
that was
Judge.
agreed upon.
Yes, Judge.
Yes.
Okay. Yeah. That's non-standard, but agreed to by both sides. 16.18, gross negligence. There's an instruction about not using the shooter's name. Maybe they should include that one. 3.11, deliberations and verdict.
Yes.
3.13, which is possible penalty. 3.14, communication with the court. 3.15, exhibits. 3.16, written or electronically recorded instructions in the jury room. 3.20, single time multiple counts, more than one wrongful act. 3.23 with regard to the verdict form, and then there's the verdict form that's standard, right?
Yes, Judge.
We have obtained a computer that would accommodate the thumb drives that's going to be in the jury room. Anything else you can think of?
I don't think so.
Your Honor, I don't have a thumb drive with mine. I just have mine. I just have a hard copy.
Oh, that's good. We'll send it all in. Okay.
Thanks.
Anything else? We're going to make those minor amendments. Anything else at this time?
No, Judge.
I don't think so, Judge.
Okay, so we'll be back in about. Oh, they're going to take her back down, aren't they? Okay. They're going to take her back down, and I'm going to ask them to bring her right back up, right? It won't take long. Okay, yeah, the jury instructions are ready. I think I'm going to give you each copy of the jury instructions just to be sure that we have it accurately, all right? And these will be the instructions that go in with the jury as well.
Thank you, Judge.
Okay. At the moment, after closings, I'm going to eventually instruct them. I am going to have all 17 come back today, right? Does that make sense to you?
I think we'll get through closings and they could start deliberating.
I'm concerned about that. Are you not concerned about that?
No, Judge.
You want to approach?
So that was, in fact, the jury instruction conference. Clearly, they had done all the work, in judges' chambers behind closed doors as far as we're concerned, because you don't blow through them that quickly, even though really it's pretty straightforward. You got 4 involuntary manslaughter counts, and that's about it. It is not a lesser included. Katherine Lizardo is still here. She's a trial attorney in the the Fort Worth, Dallas area. Sorry, I moved you. You didn't know, but you just moved across the country. Also here, Bob. One hill of an attorney. Happy to have him here, trial attorney in the area. Bob, good to have you on board. So, we jumped over a rebuttal. Are you surprised there was no rebuttal? The defense case was just the defendant, but still, surprised?
It's a judgment call. Whoever the trial lawyer is closest to the case at that point. They got this sense of where the jury's going, whether they don't want to overtry a case. If you're sitting well, sit still.
Okay, and I think, Katherine, tell me if you agree or not, the cross was probably their rebuttal, as it were. Can you bring another witness on to rebut what this parent might have said or done? If you don't have that person, somebody that specifically is available to say, well, no, she told me this, this, and this, then to Bob's point, where are you going?
I agree with you that the cross-examination of the defendant was the biggest, best rebuttal that the state could do, because ultimately it comes down to her state of mind. What did she believe in, and whether she came across as credible during that cross-examination, and especially obviously during the direct. So the jurors now will have to weigh her credibility against all of those other evidence that were presented, especially the journals of Ethan, where he was talking about his mental health issue with his parents and saying that his parents were ignoring him or not getting him the help he needed.
Okay, so what we're gonna do is squeeze in a quick break here, because we believe closings are going to start very soon. So pay very good attention to these break informational announcements, because if you really pay attention, we'll have the closings when you come back. We'll be right back.